Yes.
Your Honor, may I approach?
Yes, sir.
Is this a fair and accurate representation of the condition? Defendant?
Yes.
You recognize that?
Before we even step into this courtroom, understand this. This isn't just another routine hearing. This is a fast-moving chain of events where emotions are high, officers are on edge, and one split-second decision could completely change the outcome of someone's life. We're about to see a case involving a family emergency, law enforcement intervention, and an allegation of interference with EMS during a critical moment. The question is, was this intentional obstruction or a misunderstanding in the heat of chaos? Stay locked in, because as this unfolds, the courtroom tension only gets sharper, and the judge is going to have to make some very serious calls very quickly.
Yes.
What is it?
They're the magistrate's conditions for the defendant.
In order to the defense, Your Honor?
Okay, please. Any objection?
No objection.
Okay, they'll be admitted. States one, I guess.
Yes, sir.
Okay.
Could you please describe the conditions?
Yeah, you want me to like read all of them? Or like all of them?
Yes, we don't have an objection.
Yes. So we have defendant shall personally appear in court on time every time the court, this case is set on the court's docket unless judge waives the appearance. Defendant shall commit no crime or shall not engage in any conduct that could result in his or her arrest. We have here that they're to obtain an ignition interlock device within 7 calendar days. Is this the most recent condition? Doesn't she have a device? The device. Are these the most recent conditions? Because these are the IID ones. Can I have a moment to look at that?
Sure.
Yes, please.
These are not the most recent bond conditions that are in place. These are the first ones from the magistrate. Right now I'm printing out the amended bond conditions that were created on September 4th, the ones that we're referring to with the portable device. So the first two conditions are the same that I had stated. However, instead of the ignition interlock, we have the client is to obtain a portable device within 7 calendar days. And that would be from the date of August 28th. And then no driving without permission of the court. We have no drug or alcohol usage. And then that same day, the defendant also was required to submit to a POC test and return to court.
Your Honor, would you like me to consider these updated
Sure, of course.
with events?
So I guess states two would be the amended conditions of bond.
We're calling this stage 3, if that's okay, Your Honor.
Okay, sure.
And I have no objection to this.
Okay, it'll be admitted.
Now we will be addressing the bond violation report.
I'm going to see the witness.
Sure.
You recognize that?
Yes.
Is that called?
This is the bond violation report?
Is that a fair and accurate representation of bond violation report?
Yes.
All right, can you please explain the violations of?
Objection, she's reading from something that hasn't been admitted yet.
Mistake, Your Honor. Can you consider this to the defense?
Oh,
This will be admitted as State's Exhibit number 2, Your Honor.
Okay,
No objection.
all right, it'll be admitted.
Can you please read where it says details of the violations indicated here?
Yes, the details read that the defendant was instructed to obtain a portable alcohol testing device and refrain from alcohol consumption. From December 9th to January 14th, the defendant has generated 13 skip tests. Pretrial is unable to properly supervise the defendant if the defendant is failing to provide samples during the scheduled timeframes.
But wasn't it a condition of bond to complete those portable tests?
Yes,
And how many again were not completed or were missed?
13.
And what were the dates?
Between the dates of December 9th and January 14th.
Thank you.
Any further questions for the witness?
No, Your Honor.
Okay.
Do they prepare a report of the missed blows with the specific days?
Yes, and that was provided to everyone here's email last week or
Okay.
the week before when we had discussed it.
Okay. Ms. Giles, what is your job title, exact job title?
Judicial liaison officer.
And what do you do as part of your regular duties?
I am the face in the court for pretrial services, so I create bond conditions that are requested from judge and instruct clients over things that I can instruct over, so conditions that don't require devices in court. And if not, I send them over to our pretrial services building for further instruction.
Okay. Do you know how the portable device works?
I'm very partially familiar, but not thoroughly, no.
Okay. Do you know how the software in the device works?
No,
And do you have any idea how those work together?
no.
So when you get a report, you have no way of verifying whether that information is accurate.
The vendor sends us the full report to our case managers.
And was the full report provided in the email that you referenced earlier?
Yes,
Okay, but there's no way to know that that device is working properly from your personal knowledge.
for me to validate if it's working
Mhm.
correctly, me personally, no, but our case managers do verify it.
Okay, I don't have any further questions for this witness, Judge.
Okay. Anything further?
No, Your Honor.
Can the witness step down?
Yes.
Okay, thank you so much. All right, I guess argument. Or do you have any more witnesses?
No, Your Honor.
You have any witnesses?
I do not.
Okay, argument.
So, Your Honor, this case is pretty clear. It's a simple bond violation. The defendant here was in fact charged. We ask you to take judicial notice of that fact. And we have proven such, and that this defendant is on bond in County Court at Law number 5. And we just discussed the bond conditions that were pretty standard. And the violations here very clear that there were 13 missed portable tests. And our pretrial services was able to confirm that. And we would ask that you would revoke the bond in this case.
Judge, this is, the rules of evidence apply at this hearing. This report is testimonial. Since it is testimonial, I have the right to confront someone with knowledge about whether the machine itself was working properly, whether the software was working properly, whether the two were working properly together. And we reset this to today to get someone here who had that knowledge, was my understanding. And without that, I can't.
I didn't know about that. The only one that I knew that we were supposed to have here was Ms. Childs as with
Yes,
regard to
Your
this, not anything else.
Okay,
All
well-
in- okay,
And we
go
would
ahead.
say that the defense also has the ability to subpoena as well.
And this was set on Thursday, and it's also not my hearing, it's not my burden. I think without someone to testify that the machine was working properly, it's inappropriate to revoke her bond, restrain her liberty, the pecuniary punishment that goes with the bond revocation and paying a new bond, without knowing that the machine was working properly.
But that's on them. If there's a problem with the machine, then it's on them to go have its service or whatnot. So
Does she know it's
all I
working?
know, well, then you're supposed to go there. You're supposed to go get it checked out. We can't micromanage every single thing. Number one. Number two, this is not the first time we've had this bond violation. We've had it before and it continues to happen. I can't just let it go, man. I mean, I have to show you that we mean business. If I let you go now, then I'm enabling this behavior and I'm in effect telling you it's okay when it's not okay. You're skipping tests. It's a second offense. It's done. All right, I'm revoking her bond. She goes with you. I don't, it doesn't make me happy to do it, but I mean,
I
it's
understand.
bond violation after bond violation. I mean, all right, off the record.
Council for reset?
And
Thanks,
then you want
guys.
to address Ms. Lynch now as well?
Sure.
Okay.
Come up, Miss Lynch.
Yes.
Kelsey, we have one more. This is Miss Lynch. Guys, we're going on the record. Please keep it down. If you need to talk, go outside. All right, we're cause number 253-7045, State of Texas versus Emma Lynch. Miss Lynch was placed or picked up a DWI November 4th of 2024. She was ordered not to consume alcohol or illegal drugs. We now have a bond violation report. Today's date is February 3rd, 2025. Can you please identify yourselves for purposes of the record?
For the state, Kelsey Siegler.
Anna Edie for Ms. Lynch.
Okay. So Miss Lynch we are here now. Again, this also is a second bond violation report. The first violation was November 20th of 24. We now have another bond violation. It is a report that was filed on the 29th. Okay, State, if you'd like to continue.
There is slow, if you can just give me a moment, but this case is regarding the this is similar, not of skipping testing as well. And I'm trying to print the bond violation report and the bond conditions, just one moment. But we would call as our witness, pretrial services, Felicia Stiles, again.
Okay. Ma'am, would you come up? Would you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, please.
Thank you, Ms. Childs. Are you able to show us the bond conditions on your end if you have them on your?
Yes, would you like me to?
Yes, ma'am. Thank you. And Your Honor, we would like, if you could please take judicial notice of the file as well here regarding
Sure.
the
Any
defendant being
objection?
charged for this.
I have no issue with the,
Same as the last one.
correct, with the information.
So no objection to taking judicial notice of the file, however, not of the actual report, of the bond violation report just yet. Let her take a look at it.
Yes, sir.
So again, State 1 will be the actual condition of bond report.
Yes, sir.
Conditions and the violation.
Do you recognize this? Yes.
Yes.
What is this? Bond violation report? Can you please tell us what the bond violations were in this case?
Yes.
Oh, wait, let me actually refresh that. Do you recognize this?
Yes.
Okay, what is this?
Conditions. For the defendant.
Your Honor, we will tender State's Exhibit 1 to defense for any objection regarding the bond conditions in this case.
Judge, this says that oh, never mind. I misread that. No objection.
State offers State's Exhibit 1 into evidence.
Okay. Will
Ms.
be
Childs,
admitted?
can you please tell us, thank you, Your Honor, sorry. May you please tell us what the bond conditions are listed in this case that defendant Lynch was supposed to abide by.
So December 3rd of 2024, we have defendant to appear in court on time every time the case is set on the court's docket unless judge waives the appearance. Defendant shall commit no new crime or shall not engage in any conduct that could result in his or her arrest. The defendant was required to obtain a portable alcohol testing device that same day, December 3rd, to submit to random drug and alcohol testing, to not consume any drugs or alcohol. And yes.
These are pretty standard for this kind of case, correct?
Yes.
Thank you, ma'am. So regarding what's been marked as State's Exhibit 2, what is this?
A bond violation report.
Does this fairly and accurately depict a bond violation report?
Yes.
State tenders defense for any objections.
I would just object to, in this State's Exhibit 2 bond violation report, there's a reference to a number of skip tests. There's no dates on here, so I'm not quite sure which ones, based on the four corners of the document, we're addressing.
Okay, I guess we'll be getting into that now.
I guess so.
Okay,
State offers State's Exhibit 2.
okay, it'll be admitted.
Ms. Childs, can you please read what the violations were that are overtly obvious in this case?
The client was ordered conditions of bond that included to refrain from alcohol consumption, to obtain and be monitored by portable alcohol testing device, and to comply with required monitoring, testing, service recalibration protocols. The client was instructed to not obstruct the camera on the device and do not skip any testing windows, 5 a.m. to 8 a.m., 5 p.m. to 8 p.m., 10 p.m. to 12 a.m., blow into the portable testing device 3 times a day in accordance with the blow schedule to ensure compliance with the ordered conditions. There was a high breath alcohol content of 0.03 on 1/10 of 2025 at 10:38 p.m. The client blew into the device in the dark and her face was not able to be seen. The client failed to clear the high breath alcohol content and the allotted time. The client is also not blowing into the device as instructed. The client has a total of 15 skip tests.
And tell us what your role is in the courtroom.
A judicial liaison officer.
And you're able to testify to the bond conditions and to the bond violations.
I can testify to the bond conditions. I did not generate the bond violation report myself.
But can you attest to these dates in which the violations occurred?
I have not looked over the report recently, so I don't want to say yes.
But this is the bond violation that you've seen before.
Yes.
Okay. And it is true that the defendant here is on bond in County Court 11-5?
Yes.
I'm sorry, go ahead.
We pass the witness.
Okay. Ms. Giles, part of your job is to read the reports when they come in from the case managers,
Yes.
and then you file the bond violation report.
No, they filed the bond.
They file the bond violation
Yes.
report, and then you coordinate the,
Yes,
that with the
the
judge?
action and the
Okay.
review of it, yes.
okay. Are you able to verify the information in the report?
If I have the report, which I should in my email, if
Okay.
I take a look over it, yes.
Okay, but the only way you can verify the report is from the report itself.
Yes.
Okay, so you have no personal knowledge of the machine itself?
No.
You have no knowledge of the software?
No.
And no knowledge of how the hardware and the software work together?
No.
Okay, no further questions.
Okay. Anything further? The witness?
No, Your Honor.
Okay. So she has the first violation, right? This is the second time we have a bond violation, right? In the first one, was it that she just didn't get the device, right?
Yes, that's when we were going back and forth on the dates to get it, and we kept resetting the case because she said that she was gonna get it, and then she didn't, and then we were gonna revoke her, but then she didn't come to court, so then we sent her again, and then she didn't get the device that day, so then we gave her another chance.
Okay.
And
All right.
Judge, I don't think I represented Ms. Lynch the whole time on that, but I think some of the confusion was she was ordered to get the in-vehicle interlock and she didn't have a card.
But you did come at the time to where
Yes,
she
correct.
did get the device
Yes. And then
within,
once Miss Lynch because I believe the vehicle was damaged in an accident and she was hoping to get the vehicle out and get it repaired. And when she realized that wasn't going to be possible, she got the portable device.
My car's fixed now.
Yeah.
I started getting.
Okay, we'll get to that in a minute.
my concern is that it continues to happen. What am I supposed to do? The problem is if I let you go, I'm telling you the behavior is okay for you to do. It's not. We have court orders. You're supposed to follow court orders. You're doing what you want to do. That's not the way it works. Look, this isn't, I'll let you talk with your lawyer, but it's there. It's continuing to happen. You're skipping and you're continuing to consume alcohol. I'm sorry. I'm going to revoke your bond, man. She goes with you.
Judge, Mercedes.
Go back and I'll talk to you.
Anything else?
Judge, since she does have a vehicle, if she makes the new bond, can we switch her from the portable to the in-vehicle?
Yeah.
Okay, thank you.
Off the record.
Approaching for bond conditions on Mr. Sanders.
Thank you for being patient. Okay,
Yes, sir.
Come on.
Bring him up.
7502 on that one and the 7501 on the prior.
Yes.
At some point, someone is going to stop bailing you out. No more dope. Do you understand? I'm going to test you within the next 2 to 3 weeks. If I find that you continue to use, we'll just continue to play the same game. No more. Do you understand? If you have a problem, address it, because if you don't, I will do it for you, and you're not going to like the way that I do it. Okay? All right, same conditions, no alcohol, no drugs, random testing. I'm going to test them within the next 2 weeks. Be ready. Okay? All right, thanks. Yeah.
Yeah, shoot for a plea, Your Honor.
Good.
Either way, you're getting this thumbprinted.
Mr. Bailiff, you want to talk to me while we're waiting?
On trial for tomorrow.
Okay?
Just see if we're first up or if we're in custody, see if we're going tomorrow.
Don't know. Talk with Kelsey. Let me know, please. Okay. Bless him. Ready? Okay. Good morning, Mr. Chook.
Good morning.
Mr. Chook, you were charged with driving while intoxicated. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you have done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. Whenever you get pulled over, an officer, the first thing they do is they look at your criminal history. If they come to your window, they smell alcohol, and then they look you up and with a prior to DUI, it's probably not going to go well for you. Do you understand? Shh. From now on, you are facing a minimum of 90 days in jail. So if you're not in this country with permission, you do that kind of time, you can almost rest assured that you'll get an immigration detainer. Do you understand? What I'm trying to impart to you is that if you want to drink, don't get into a car. Even a sip of alcohol, you're going to end up with us. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. You understand? Do you still want to do this?
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'll find you guilty. I will follow the agreement. I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir. All right.
Judge, what about the,
CC.
is it true that he had a,
Oh, I'm sorry. Is it true or untrue that you had a 0.15 or above in your breath test or blood test?
That's what came out of that.
Let's pause right here because this is the turning point of the entire case. EMS is actively trying to provide medical assistance, and according to the officer's testimony, the defendant physically grabs the EMS responder's arm while they are attempting to reposition and treat the patient. Now, legally speaking, this is where interference with public duties becomes very serious. Emergency responders are protected under the law because they are performing life-saving actions. Even a momentary physical obstruction can escalate charges quickly. But here's the key question for the audience. Was this an intentional act of interference or a panicked reaction from someone watching a loved one in distress? The courtroom is now shifting from medical emergency to criminal liability in seconds.
Is it true or untrue?
Yes, it's true.
Okay. All right, guys. Good luck.
Judge, can we come again with one Spanish, please? Thank you.
What's the name?
Top of page 25.
Montanes, come up. Mr. Montanes, do you have a lawyer today?
Not, I don't have one right now, but since I haven't been working too much.
Did you want to apply for?
¿Quieres aplicar por uno de oficio o vas a ocupar tu
No,
propio?
para la otra vez ya lo traigo.
The next time I come, I will bring one.
Your case is 90 days. It's now, I'm going to give you just a couple weeks. Your case is very old. You were supposed to have a lawyer by today. I will give you a couple more weeks.
Oye, darme
Are you sure you don't want a lawyer now? You're not working, are you?
Yo lo voy a agarrar.
No, I'm gonna hire one.
Okay, I will give you 2 weeks. At that time, I'm going to appoint you a lawyer.
Le voy a asignar uno.
All right, thanks. Please take a seat. Hi. Lasta, thank you so much.
Sure,
Yes.
Okay.
Your Honor, I have someone in custody, Hugo Martinez. I was appointed this morning. He just needs bond conditions, Judge. Your Honor, I understand that he has.
He has an ice hold.
Yes, Judge. He posted bond in immigration, and then he's paid his cash bond here too. So I'm
Oh,
gonna
really?
get
Okay.
in contact with the immigration attorney with that hold.
Do you mind bringing out Mr. Hugo Martinez, please? Okay, I'm going to talk to them real quick.
Yes, Judge.
Give me 2 minutes. Joseph, ready? Is your guy here?
I'm circling back on my client that we
Yes.
spoke about on.
Is he here?
Monday. He's here.
Bring him up, please.
Mr. Hernandez?
How's it going?
Not good. I understand the seriousness of the charges. I've had 3
Not
weeks.
necessarily that, but that you need to understand that it is an absolute privilege. It's not a right. And there are certain things that are elementary in life. And one of those things is